A 9-0 Supreme Court ruling just hit, and it could decide whether a traffic stop ends in truth or a clean legal cover story. On May 15, 2025, every justice agreed that courts can't ignore what police do before the trigger gets pulled. If you legally carry a gun, that matters more than most people realize, because one bad stop, one rushed command, and one panicked second can change your life forever. This didn't happen in some distant corner of the law. It landed right in the middle of the road, where everyday drivers and armed citizens meet the state face to face. Most people hear police shooting case and tune out because they think it has nothing to do with them. That's a mistake. If you own a firearm, keep one at home, carry in your vehicle, or lawfully wear one on your hip, this is your world too. The same Constitution that protects your right to keep and bear arms also controls how the government can stop you, search you, grab you, or use force against you. And during a traffic stop, those rights collide fast. What makes this ruling so important is the trap it shuts down. For years, some courts acted like the only thing that mattered was the final heartbeat before a shot was fired. They would zoom in on that last tiny slice of time and pretend the minutes before it barely existed. That gave officers a huge legal shield in cases where their own choices may have created the danger. If that sounds backwards, that's because it was. The information I'm about to share could literally save you during a police stop. But first, are you subscribed? If you care about your rights when you're behind the wheel and armed, keep up with this, because the fine print in cases like this matters more than people think. The case is called Barnes versus Felix, and the basic question was simple. When a court decides if police use too much force, does it only look at the split second of fear, or does it look at the whole event from start to finish? Ooh. That sounds like common sense, but for a long time, common sense was not winning everywhere. In several federal courts, judges used a narrow rule that treated the final moment like it was the whole story. That older rule worked like this. If an officer said he feared for his life at the instant he fired, the court often focused right there and mostly stayed there. It could push aside what the officer did earlier, what commands were given, whether those commands made sense, and whether the officer stepped into danger that didn't need to happen. So even if the setup was chaotic, reckless, or avoidable, the legal lens became tiny. It was like judging a car crash by looking only at the last frame of a video. Now think about what that means for someone carrying legally. You can do almost everything right and still end up in a terrible situation if an officer gives bad instructions or misreads your movement. If the law only studies the final flash of motion, then the story gets twisted. It stops being about the whole stop and becomes only about the officer's fear in the final second. That's not a full picture. That's a snapshot with half the facts cut off. The facts behind this case are exactly why the Supreme Court stepped in. Back in 2016, a man named Ashtian Barnes was pulled over near Houston after an alert tied his plate to unpaid toll issues. The officer approached, asked for documents, and the stop started like many others. Barnes didn't have his license on him, and the car was a rental. Then the stop began to shift from routine to tense. The officer said he smelled marijuana. Barnes said his identification might be in the trunk, and the officer told him to open it from inside the car. Barnes restarted the ignition so he could do that. Then everything sped up. The officer opened the driver's door, drew his gun, Barnes drove forward, and the officer jumped onto the side of the moving vehicle. That part matters more than you might think. Once the officer was hanging on the vehicle, he shouted, and then fired into the car within seconds. Barnes was hit and later died, though he managed to stop the vehicle first. The lower courts looked at those last moments and said a reasonable officer could fear for his life while clinging to a moving car. On that narrow view, the shooting was treated as justified. But here's the part that should stop you cold. The courts barely dealt with the officer's decision to jump onto that moving vehicle in the first place. In other words, the act that may have turned a dangerous moment into a deadly one was pushed to the side. That's the kind of blind spot this case was really about. And if that kind of blind spot exists in law, it can affect anyone in a stop, including a lawful gun owner trying to comply under stress. Imagine a referee who watches a fight, ignores who threw the first punch, ignores who cornered who, ignores every warning sign, and then judges the whole event by the final swing. You'd never call that fair. Yet that is close to what this narrow legal rule did in some police force cases. It told courts to wear blinders. It told them to ignore the road that led to the cliff. The Supreme Court rejected that approach in a unanimous voice. Not 6-3, not 5-4. All 9 justices said courts must look at the totality of the circumstances, which in plain English means the whole situation. They said judges cannot put on chronological blinders and pretend earlier events don't matter. That phrase is a big deal because it wipes out the idea that only the final instant counts. That does not mean the court said the officer in this case definitely acted unlawfully. It did not hand down a final answer on guilt or innocence. What it said was that the lower courts used the wrong test. The case has to be looked at again with the full timeline in view, including the officer's actions before the shooting. That alone is a major shift because the legal frame is now wider and more honest. If you're getting value from this, stay with me all the way through, because the biggest takeaway isn't just about one family or one lawsuit. It's about what happens when your Second Amendment life meets a Fourth Amendment stop. That overlap is where confusion, fear, and bad decisions can explode, and the law just changed the way those explosions get judged. This is why lawful carriers should pay very close attention. Every time you get pulled over while armed, you're stepping into a moment that can go sideways fast, even if you are calm and respectful. Your firearm may be legal, your permit may be valid, your hands may be doing exactly what you were told to do. But if an officer gives poor commands, switches instructions, or reacts before thinking, that final second can be made to look very different from the truth. Take a simple example. A driver is carrying legally, and during the stop, he tells the officer about the firearm the way his state requires. The officer asks for a wallet, registration, or permit. The driver reaches where he was told to reach, but the gun is also in that area or near that area. If all a court studies is the instant the hand moved, the driver can look like a threat even if he was following instructions. Under the Supreme Court's ruling, the court must now ask harder questions. What exactly did the officer say first? Did the officer know the person was carrying lawfully? Were the commands clear? Or did they create confusion? Did the officer order movement toward the same place where the gun was located? Those facts are no longer background noise. They are part of the legal test. That matters because real traffic stops are messy. People are nervous. Officers are nervous. Engines are running. Seatbelts, trap movement, dark roads make everything harder. If a legally armed driver gets hit with conflicting commands like keep your hands up, show me your license, and don't reach, all in a rush, the body can freeze or move awkwardly. That awkward movement can become deadly if the law refuses to examine how the confusion was created. And there's another layer here that a lot of people miss. The court did not settle every issue in this area. It did not fully answer whether an officer loses legal protection when he recklessly creates the danger himself and then uses deadly force to escape it. That question is still alive. The justices basically said that issue wasn't fully dealt with below because the lower courts were using the wrong narrow lens. That unfinished question is huge for the future. Because once courts are required to study the full timeline, they will keep running into the same hard problem. What if the threat at the end was real, but the officer's own choices set the stage for it? What if the danger was not random, but built step by step through poor commands, bad tactics, or needless escalation? Those are not anti-police questions. They are constitutional questions, and that's an important point. This ruling is not a declaration that officers can never use force during a traffic stop. It does not say every shooting is now unconstitutional. It does not tell courts to ignore danger or second-guess every split-second choice from the safety of a courtroom years later. What it says is more basic and more powerful. You cannot judge reasonableness honestly if you pretend the earlier facts do not exist. That should matter to anyone who believes in both public safety and civil rights. Police do face real danger on the roadside. Everyone knows that. Cars are weapons. Stops are unpredictable. Officers have been attacked during routine encounters, but none of that erases the need for fair review. If the law allows only the final second into evidence, then review is not fair. It becomes a ritual where one side starts with half the story missing. A lot of lawful gun owners understand this instinctively because they live with rules, training, and responsibility every day. They know that context matters. A hand on a grip can mean threat, or it can mean someone trying to secure a firearm, comply, or prevent a misunderstanding. A movement toward a waistband can be dangerous, or it can be the result of a shouted order given 2 seconds earlier. Context is the difference between truth and distortion. If you know someone who carries, drives long distances, or keeps a firearm in the vehicle, this is the kind of video they need to hear all the way through. Send it to the person who assumes the courts will sort it out if something bad happens. Cases like this show that what the court is allowed to look at can decide whether justice even gets a chance. There's also a broader signal in the fact that this ruling was unanimous. In a time when almost everything feels split down the middle, all 9 justices agreed that the law cannot be reduced to a freeze frame. That tells you the problem with the older rule was serious. It also tells you this issue reaches beyond party lines. The court saw a basic flaw in how some lower courts were handling police force cases, and it moved to shut that flaw down. For everyday people, the practical meaning is simple. If a stop turns ugly, the full encounter matters more now than it did before in those places using the narrow rule. Commands matter, timing matters, escalation matters, the officer's choices matter. Your behavior still matters too, of course, but the legal system is not supposed to ignore the setup and stare only at the bang. That is a real improvement, especially for people who lawfully carry. It also means departments, lawyers, and judges will have to adjust. Police training may need to focus even more on clear commands, spacing, de-escalation, and avoiding tactics that trap everyone into a deadly split second. Lawyers bringing civil rights cases now have stronger footing to argue that the whole scene belongs in court. and judges reviewing those cases have less room to hide behind an artificially tiny timeline. For gun owners, this should reinforce something important. Your rights do not travel alone. The right to keep and bear arms is one piece of the constitutional map. The right to be free from unreasonable government force is another. When you carry in public, those two rights can meet in a single moment on a roadside shoulder. That's why legal awareness matters, not to help you pick fights, but to help you understand the ground you are standing on. None of this is a license to act careless during a stop. It's the opposite. It's a reminder that small moments matter. Keep your conduct steady. Know your state's carry and disclosure rules. Avoid sudden moves. Don't turn a tense stop into a louder one. This case is not about beating the system with tricks. It's about making sure the system cannot erase the early part of the story if something goes terribly wrong. And for families, this ruling matters in a very human way. When someone is shot by police, the public often hears one sentence repeated again and again. The officer feared for his life. Sometimes that fear is real and unavoidable. Sometimes the road to that fear is more complicated. A full legal review cannot bring a person back, but it can at least force the system to confront the entire chain of events instead of hiding inside the last instant. That is the heart of this case. Not politics, not slogans, not easy sides. The question is whether the Constitution still requires honesty when the government uses force. The Supreme Court just answered yes. Courts cannot crop the video down to the 2 seconds that help the state the most. They have to look at the build-up, the commands, the movement, the decisions, and the danger as a whole. If you want more breakdowns like this in plain English, hit subscribe and turn notifications on. These rulings don't stay locked in law books. They shape what happens on highways, in parking lots, outside homes, and in everyday stops involving ordinary people who thought they were just driving from one place to another. There's still more to watch in the months ahead. The Barnes case goes back down for a new review under the correct standard. Future lawsuits will test how far this full timeline rule reaches. And one day the court may directly answer the harder question it left open here about officers who create the danger themselves. So this story is not over. In a real sense, it's just entering the phase that could affect even more people. But even before those future cases arrive, the message is already clear. The government does not get to erase the lead-up and keep only the ending. If police use force during a traffic stop, the law must examine the whole scene. That protects the innocent. It helps expose reckless conduct. And it respects the simple idea that truth usually lives in the full sequence, not in one isolated second. So bring it back to yourself. If you are a lawful gun owner, a regular driver, or someone who cares about constitutional limits on state power, this ruling has your fingerprints on it. It speaks to what happens when ordinary life crashes into official authority. It reminds us that rights are not abstract words. They live or die in moments of pressure, confusion, and fear, often on the side of a road with flashing lights behind you. The Supreme Court didn't hand gun owners a magic shield, and it didn't tie officers' hands behind their backs. What it did was force the legal system to stop cheating the timeline. That may sound technical, but it is not small. When the full story can be heard, justice has a better chance. When only the final instant is allowed in, truth gets strangled. Remember that the next time someone tells you these cases are only for lawyers or activists. They're not. They are for the person driving home from work with a legal firearm in the car. They are for the spouse waiting at home. They are for the family trying to understand what really happened after a stop turned violent. And they are for every citizen who believes constitutional rights should still mean something when pressure is highest. If that message hits home, subscribe before you go and share this with one person who needs it. Not because fear should run your life, but because knowledge matters when seconds count, and the fine print decides what the court is allowed to see. The law just got a little more honest, and for anyone who values both safety and freedom, that is worth paying attention to. At the end of the day, this ruling comes down to one basic idea. The Constitution does not vanish in the final 2 seconds of a police encounter. A lawful carrier, a driver, a passenger, a family member, all have a stake in whether courts look at the full chain of events or only the piece that makes the shooting easiest to defend. 9 justices, 0 dissent, and 1 clear warning to the legal system. Stop wearing blinders. The whole story counts now, and for millions of Americans, that could make all the difference.